Wagon people. Rise and shine. Day 2. Kartel court hearing. Privy council court hearing at that. So basically I go kick off the live stream now. You see me? So it basically start now. So we are gonna kick it off. Remember, everybody we are forwarding upon the live. Leave a like, you see me? Just like up the live quick and fast. You see me? So YouTube can push out the live said way, you see me? Yeah, and that we are jumping at right now.
That he returns and he takes Mr. Palmer to hospital. After that, he is offered, they try to get him, Chow, to leave the country along with them a few days after. That's the thrust of his evidence. Now, that was obviously evidence subject to a lot of challenge, but the real point about it is it was supported by all the technical evidence. It was supported by the technical evidence, the phone calls and so forth. Well, that was one category. The second category was the deceased girlfriend's evidence, to the effect that the deceased was never seen after the 16th of August 2011, the inference being he was obviously killed on that day, as Choud said. The third category was the evidence of the police investigations after the killing, and in particular, the entire interior of the house where the killing took place was burnt on the 27th of August, about 2 weeks later. There was a foul odour there on the 29th of August, query what was going on, and then by the 30th of September, the entire rear of the house had been demolished. And that is, you get that at the Court of Appeals judgment 5780, paras 14 to 5781, 17. And the appellants were arrested on the 30th of September 2011, and that's 5781, 18. And the point about the burning of the houses is that this was Palmer's house, and there was no report of any damage being done to the house at all by Palmer, and that was a point that was made to the jury. How come, if he owns the house and it's been damaged or burnt down, or burnt at least, how come he makes no report of it at all? The next category of evidence was Exhibit 14C. That consisted of voice and text messages from Palmer, and they are summarised at E5803 to 5807, and they are also summarised in the SFI at E6135, para 10, to 6136, para 13. If I can just ask you briefly to look at the Court of Appeals summary of that evidence, because it just couldn't be clearer. E5803. A big passage describing Exhibit 14C begins at paragraph 69, and then paragraph 70 describes or summarises the effect of the voice notes. In the original, they're quite difficult to follow because they're all in patois. But you can see if you read 70, paragraph 70 at 5803, on to, if I may ask you just to read yourselves to 5806, the end of 5806, you can see the nature of this evidence. And in particular, you will have seen in passing, 5805, paragraph 73. This is Palmer's text a few days after the event. Between me and you, the recipient's not identified, we chop up de boy lizard, that's the deceased's nickname. Fine, and dashing we enough. As long as you live, dem can never find him. Oh, couldn't be clearer. But the whole picture couldn't be clearer. And then we have also from JS2, I'm just going to give you the references. We have the texts between the deceased and his girlfriend, in particular on the 16th of August 2011. They are summarised at E4788 to 4791. And you can also see a shorter summary at in our written case at 6227.
Can you just give those references again?
Of course. Yep. 4788.
Yes, thank you.
4791. And in our case, they're summarised again at 6227, paras 40 to 41. But those texts show without a shadow of doubt that the deceased was on his way to be executed, and he suddenly realised what was going to happen to him. There can't be any doubt about that. There are some texts also from Palmer. They were of no significance, but there were texts from Sean Campbell, which to an extent were incriminating, which suggested that on the day of the killing, but before the killing, Campbell said, who thief it, go dead. That's say, whoever stole it is a dead man. And then after the event. But the references, you can see those texts at 4989, lines 1 to 14. And 4990, 13 to 4991. So they're plainly incriminating. Now, the defence cases, and it's important to understand what the defence cases were, they all just gave unsworn statements. Palmer's case was simply that he had never met Lizard at the premises on the day in question. And, my lords, that is at 4341. I should emphasise this. The SFI says that Palmer says he wasn't at the premises. That wasn't actually what he said. He said, I didn't meet Palmer. I never met Lizard at the premises. Rather different. So he doesn't give an alibi. The important point is he doesn't say, I was at a concert or whatever, somewhere in Kingston. No alibi. Campbell, in his unsworn statement, accepted that he drove, he says, ahead of the deceased and Chow in another car to the premises, but he says the deceased got out before getting to those premises. And when Campbell got there, when Campbell got to the premises in question, he says he left Chow there. In other words, Chow did go there, but Campbell says he then left. And later, he saw that Chow, later that evening, he said the only thing Chow mentioned was that Palmer had received a dog bite and had to be taken to hospital. That's 4383 to 4386. Jones's defence was a very short statement. He just said the police were lying about him. That's 6137 at 16, or that's the, I think, of the SFI, and in the record, 4387 to 8. And St John said he left the premises just as Chow entered, and he saw Palmer getting bitten by a dog. And that's 4390 to 4392. But the short point is that there was no denial, as far as one could take out, that they were there. And that is significant because the premises are then subsequently destroyed a few days later, or partly destroyed. And there's no explanation for this. Now, as to the exhibits, X14C, Exhibit 14C and JS2, their cases were simply this. The police have fabricated them. There's just a giant conspiracy to fabricate a whole mass of evidence. And there were challenges to the chain of integrity that went to that. That was it. But there was no explanation as to why the police should have done any of this at all. Now, my lords, bearing all that in mind, we say this was an overwhelming case where, for some reason, the only real question was, were the police in some way motivated, or did they fabricate all this evidence? That was the question for the jury. And, my lords, my lady, I respectfully submit there was nothing to support that. It's difficult to see, therefore, in those circumstances, why the alleged or rather what you might call the bribery, would have made any difference to the consideration of their verdict. And I do submit the strength of a prosecution case in circumstances like this is a material factor. When one is asking, the question is there a risk, a real risk, that the verdict was influenced by prejudice? And I say, no, there's no real risk of that. My lords, my ladies, as far as the jury retirement point is concerned, that's what we say. So we say there was a fair trial, and the fundamental point is you can be satisfied that that 10-1 verdict was a verdict given by the jurors, or the 10, in accordance with their oath, uninfluenced by bias, prejudice. And if that's right, I submit the appeal must be dismissed. The next question I can deal with very briefly is the jury retirement point. My lords, my lady, I submit the following very short points. At the time, that's in 2011, there was no established practice written in a bench book or anything like that. The matter was left to the judge's judgment as to when to send the jury out. Second, I am informed by the Director of Public Prosecutions, who was here, who will provide more detail on the point. In real life, juries never take more than about a couple of hours or so to come up with their verdicts, even after long trials. And it is unheard of for them ever to have to be sequestered in a hotel room overnight. It just doesn't happen. Thirdly, there was, in my submission, no pressure applied by the judge in his directions. This is not a case where there was something the judge said at some point which suggested to the jury, you better get on with it. Far from it. There is at no point anything which the judge says to the effect, I do want you to come back in an hour or so, or please make your minds up, and so forth. So, nothing at all. No criticism of what the judge actually says. And finally, and I submit importantly, the Court of Appeal, who know all about this, how the system works, saw nothing wrong in what had happened. And if I can give you the reference, it's E5854, paragraphs 203 to 205, where they describe, where they go through some of the cases about sending juries out in different jurisdictions, and then again at 209, where they come up with... 5854. Paragraphs 203 to 205, where they discuss the background and various other cases, and 209. And they discuss one or two Privy Council cases where juries have been sent out actually rather later, but although the Privy Council has disapproved of that, nonetheless the convictions were upheld. But in my submission, the Court of Appeal was perfectly entitled to come up with the conclusion they did. No error of law has been identified in anything the Court of Appeal said, and I submit it's not right, it's not the board's place to interfere with the Court of Appeal's judgment on these matters. Very briefly, the proviso, in one sense, my point on the proviso is this. Even if, let us say, the judge's directions after the jury incident were not as strong as they could have been, or should have been, or even if the retirement was too late in the day, there is still no reason to suspect that the jury was infected by bias or the risk of bias, given all the matters I have said. That being so, even if there was some irregularity or some imperfection in the way the trial was conducted, this is a case where there has been no, to use the words of the statute, no substantial miscarriage of justice. I should emphasise that I accept that if there was a risk of bias, a real risk of bias in the verdict, that would mean the trial was unfair, and that would also mean that you couldn't apply the proviso. An unfair trial is written water. But if the trial was fair, in my submission, you apply the proviso.
Do we have the statutory provision that contains the proviso?
I think we do. Yeah. In the bundle. For some reason, I seem to remember reading it recently. If I'm wrong, I'll be corrected. Perhaps I can...
Perhaps you could have the reference later.
I'll give you the references if I can find it.
Thank you very much.
My lords, my lady, that is only one point.
Yes, I think it's page 6806.
Thank you.
I think it's in the standard form of wording you're probably familiar with from other jurisdictions.
Well, I have noticed that they vary on
Well, the one we've been given.
That's why I asked.
is the Judicature Appellate Jurisdiction Act, and it's section 14, the proviso to section 14.1.
Thank you.
No substantial miscarriage of justice test.
Yes.
And that's why I say there is, subject to the unfair trial point, subject to the unfair trial point, there's no unfair trial, the proviso I submit applies. The final question is that of remission. In my submission, this could hardly be a more serious case. It is of particular concern that we are talking here about great celebrities. That doesn't mean that you apply a different standard, but of course it does mean, in my respectful submission, such a high-profile case with, on the face of it, such overwhelming evidence. Most of it, of course, not the entirety of it, being of a technical nature and so forth. I submit this would be an appropriate case for the matter to be remitted for a retrial. My lords, I don't think on the whole you yourselves do that. You normally send it back to the Court of Appeal to consider. But I would submit there's every reason, if I'm wrong, for the Court of Appeal to consider what to do. My lords, those are my submissions on the main point. I've only got a little bit of time on the other points. I think I'm right to say my lords, you have seen our written case.
Yeah, this is the JS2.
Yes, the JS2 point.
Want to hear about it? Or do you want to go off the bench?
Should we rise for a minute?
Yes. Mr. Knox, we'll rise for a moment or two just to consider whether we need to hear you on the JS2 point.
I'm obliged, my lord.
So, alright, people, so they might take them first break. So it seems as if two of them might take more than 2 breaks. So we are wait them for forward back. So in the meantime, like up the live for me, you see me? Yeah, man. I will pound up on the live and I'll know when I have to reach over 50 likes. So just click off of the comment section here and like the live. You see what I say? I want to say free world boss. Check the comment section. No, it not done, Thomas. Them just take a break. So them gone deliberate among the privy councils. It's gonna be a long day. You see me? It's gonna be a long day. So today a final day, so them have a whole heap of things for cover. You see it? Yeah, man, we can't wait to hear the verdict for real. So I feel like say dog have a more than 50% chance. So people, over 300 are with upon the live. Only there are 67 likes. At least get the likes up to 100 likes. You see me? And for the people them we are join and I done the stream done, them just a take them first break. So them soon forward back, you see me? Yeah, so if everybody will just a join, yes, they're on break. They said they're gonna take a moment or two to do some deliberation, so them soon forward back. You see me? But in the meanwhile, like up the live for me there. You see me? Hold power up on the live. We must can get it over 100 likes. So like up the live, please and thanks. You see me? And good morning to everyone. Yeah, bright and early there. I do it. Is it? Yeah, so if everybody will just a join, yes.
We don't require to hear you on the JS2 issue, Mr. Knox.
Obliged, my lord.
Thank you very much. Yes, Mr. Southey.
My lords and my lady, can I deal with my learned friend's submissions, not in the order in which he made them, but hopefully by topic, because that may assist, I hope. At the heart, obviously, of my learned friend's submissions was a submission, essentially, that the way in which the court should look at this was in two stages, the jury issue. The first being, was the judge obliged to discharge one juror, and the second being, was the judge then obliged to discharge others because of the potential impact of that one juror. Our submission is that that approach is flawed, and we make that submission for two reasons, two independent reasons. The first is this. My learned friend said, albeit slightly half-heartedly one might think, when asked a question, that the test essentially that should be applied is not the Porter and McGill-Lowell test. It was one that I think he referred to it ultimately as being possible bias, not appearance of bias. In other words, as I understood it, actual bias, not apparent bias. In our submission, that was an important submission for him to make, and he needed to make that for two reasons. Firstly, because he accepts that ultimately this jury included, to use his language, a bent juror. In terms of the fair-minded bystander, that immediately must raise eyebrows. But secondly, probably more importantly in one sense, his submissions this morning focused on what whether or not the judge was acting reasonably. That, in our submission, is not ultimately the key question. The key question is whether or not the fair-minded bystander would effectively conclude there was a real risk of bias. Now, the fair-minded bystander test has been consistently, I'll just give you the references to it, applied by criminal courts. It was applied in Brown, as you saw when I opened, which is at page 6330, paragraph 38. It was also applying Brown in Morrison, which my learned friend took you to, page 7564, paragraph 36. And there's good reason for it to apply. There's no suggestion anywhere that in any case law that there's a different test, but the good reason for it, and it links in with the submissions I made yesterday about Lowell. You'll remember in Lowell, which is 6318, the court emphasised essentially that the reason for the fair-minded bystander test was the need to ensure that there was confidence in the justice system in a democratic society. The language used, if I remember rightly, is public perception is key. And that need for public perception it must apply equally as powerfully in crime, if not more powerfully, where liberty is at issue. Confidence in the jury system is important. That was part of Lord Justice Bingham's, as he was then, remarks in Putnam. And so public confidence remains as important. And it should be noted, again, I won't take you to it given time, but in Gregory in the United Kingdom, consistent with what I've just said, a criminal case, 7930, the European Court of Human Rights started by directing themselves that courts must inspire confidence, same principle as Lowell, paragraph 43, and referred to the need for there to be impartiality subjectively as well as objectively. In other words, it must appear, a criminal court must appear unbiased. And there is nothing in our submission that supports a departure from Porter and McGill. One thing I should say, just because there was some suggestion about what was argued in the Court of Appeal, paragraph 240 of the Court of Appeal's judgment expressly refers to an argument that Porter and McGill applied. It was said that the judge had applied the wrong test. That's electronic bundle 5870. That is preceded, just in terms of what's argued, at reference page 5867 to 68. paragraph 234 by reference to the fact there was an argument about overcompensation. So overcompensation clearly was before the Court of Appeal.
What was the paragraph reference for that?
234.
234, thank you.
Second point, whether or not I'm right about the first point, in our submission, the prosecution's approach is essentially of saying you can have a jury with one biased member and it's still a lawful jury is inconsistent with the statutory scheme. And there are a couple of features that I'll just remind you of. Firstly, if you go to, and these are 6803 or the new version of the Jury Act is in same terms essentially for these purposes. 31.3, you will remember, is the provision that talks about how a jury is properly constituted if it's not reduced by more than one. Well, if you are discounting someone essentially on the basis that they no longer should properly be a member of the jury because they are bent, again to use that language, in those circumstances, the jury ceases, we would submit, to be properly constituted. Now, one particular reason for that is that if you look at 31.4,
it might be helpful for us to have this in front of us in the correct version, which was sent by email to us earlier this morning.
I'm sorry, I've got it. That's why I've got the iPad up, so I've got the correct version. So I don't think the language changes for these purposes, but I absolutely accept the point that it's better to have the source.
What time is it sent? My email has crashed.
Oh, I see.
Added to SharePoint.
It was.
It's on SharePoint.
I'm disconnected. I'm disconnected. Yeah, I'm disconnected. I'm not getting any emails. Yeah, I got it.
I think within the internal pagination, it's page 18.
Yes.
I think four of us have the.
Sorry.
Latest version. My email is disconnected.
I'm sorry.
It should be on SharePoint as well.
No, this version came in. Yes. Yes, it's not appeared on mine, probably for the same reason.
You just have to manage.
I'll manage. Yeah.
Yes, Lord Lloyd-Jones will manage with the
Thank you.
2016 version.
Thank you. 31.3 is the provision essentially that talks about a properly constituted jury and makes it clear that if the numbers are not reduced by more than one, the jury remains properly constituted. Well, we would submit that if someone is biased and essentially being discounted by the judge as on the basis that essentially the verdict can be delivered by 10, that is inconsistent with 31.3. But 31.4, even more importantly, in one sense, deals with what a verdict of 11 jurors, a verdict of 11 jurors is treated. It provides that it will be unanimous, essentially, deemed as unanimous, even though one person has been discharged, demonstrating really that the expectation of the legislation is that all jurors will participate. And that's even clearer, we would submit. If you go down in the version that we've got to, it's page 24 within the pagination of the document, section 44(1)(a), which is the provision that allowed a majority verdict. And of course, that provides, as the court's well aware, and as is common, that you can't immediately go to a jury verdict. And that's important because what it's demonstrating is that the starting point should be that all jurors participate in the verdict, and all jurors should, as far as possible, be in agreement about the verdict. If that's not possible, then you can go to a majority verdict. But the view is that everyone should participate. All of that explains in our submission why, and none of this is sort of unusual or it's reflected broadly in similar provisions or similar approaches in England and Wales. All of that explains why in Putnam, you will remember, and it's page 7579.
Sorry, yeah.
Sorry.
Can I just check? Are you able to help us on whether the murder is likely of murder falling within section 44(1)(a)?
Yes, capital.
It wasn't, and that's why when I used 44(1)(a), I meant capital A, not little a, because that's why the majority verdict could be reached, as obviously it eventually was. But as I say, the key point we make about that is that demonstrates the idea that the jury should, as far as possible, be coming to a collective decision. And that all explains. You'll remember, if you go back to Lord Bingham at Lord Justice Bingham, as he then was, at 7579, the passage towards the bottom of the page that I took you to yesterday, Lord Bingham bases his approach in circumstances where, on the material they had, essentially, it was one juror who was approached. He bases his approach on the need for collective and individual integrity. He's making it clear, and we would the decision that we produced yesterday from the Guyanan Court of Appeal. It explains why a trial without its full numbers can't be regarded as a valid trial, even though in principle it might have been possible to proceed with the number that was who were actually involved in the verdict. And fundamentally there is a good reason for that, and it's this. Everyone remembers, most lawyers remember very strongly 12 Angry Men. And it's the point about that is you can have one member of the jury who is completely out of line with everybody else, who persuades everybody. And your right is to have that one person come forward. And one of the real risks in these circumstances is that the corrupt juror, my learned friend, because he needs this, has to accept that the corrupt juror can participate. It's potentially important he participates because he might be the minority, the person who is going to try and persuade everybody else that he's right on the evidence. But of course, there is then a problem because all the other jurors, if they're aware of this, may well, understandably, want to discount his views perfectly properly in one sense, you would think. But that's the fundamental problem that you've got in this case. And that's one of the reasons why you can't separate this, because you can't separate the questions in the way that my learned friend does, because he needs to say, because he needs the corrupt juror to remain on the jury, that corrupt juror needs to be able to participate in principle in the decision making, but it's very difficult to see how they can do that without then there being a problem. And all of that statutory scheme obviously needs to be viewed in light of the fact that there is a right under the Charter, Section 16, to an independent and impartial tribunal. And my learned friend took you to the structure of the Jury Act. He made a number of points. His basic point was essentially that although if you had an incapable juror, for example, someone suffering from mental disorder, they would have to be discharged. But in some sense, a biased juror was different. But the fundamental problem is, with that submission, that the biased juror, of course, is incapable of complying with their oath by definition. If they are biased, the oath, in this sort of situation, in any event, the corrupt juror has already said that they're not going to comply with their oath. Why are they any different to others who are effectively discharged because they're unable to comply with their oath? Now, my learned friend in its submissions, essentially argued that one of the reasons why the judge wasn't obliged to discharge the briber was that they apparently favoured the defendant. And he emphasised the fact that the forewoman had given evidence, or had given an account that nobody was listening to the person offering bribes. I think the reference is Electronic Bundle 517221. But that demonstrates in one sense the problem, because it demonstrates how once you've got to this situation, you're not adopting, the jury wasn't adopting the Putnam approach. It wasn't taking collective responsibility, essentially. It was saying, you need to be isolated. In terms of the impact on the jury, what Malone and Friend failed to address in my submission is how the judge was actually in a realistic position to address and understand the impact on the jury. He had no evidence about how long the jurors had been aware of this, the Putnam point that the longer you're aware of it, the more embedded prejudice can become. He had no explanation as to why the jurors hadn't drawn attention to it. The jurors were not asked individually if they could put the bribe to one side. And so, on the face of it, he had very little information about impact. And that meant it was very difficult, we would submit, for him to assess. Now, his sort of fundamental point about considering the impact is that what the judge was entitled to take account of, or what justifies the approach of the judge, was that discharging the whole jury would have brought the system into disrepute. It would fundamentally undermine the jury system. Firstly, there's no indication these circumstances are common, but if there is a problem along those lines, the answer is for the legislature to introduce legislation such as England. If the system becomes undermined, essentially, there are solutions. The solution isn't to allow a trial to continue in circumstances where there is a lack of independence. That was the context, though, of Malone and Friend's submissions, which fundamentally were that the judge's discretion was exercised correctly in not discharging the jury.
I take it there's no evidence about jury tampering in Jamaica that's before us?
No.
Thank you.
Not that, certainly not that I'm aware of. The Malone and Friend's next submission, based on what I've just said, was that the judge exercised his discretion correctly. It was an exercise of his discretion. Firstly, given what I've already said about the Porter and McGill test, the Lawal test, in our submission, that's the wrong question. The real question here is, was the constitutional right to an independent trial by an independent court breached? That's important because the suggestion was essentially all that the judge had was a mere allegation. Firstly, we of course know that there was in fact a conviction, but secondly, in any event, the issue is real risk. Malone and Friend said the judge was entitled to rely on the forewoman's role, and in particular the fact that she said that none of the other jurors had taken a bribe and that they would follow their oath. Part of the problem with that, the primary problem with that, of course, is where you have unconscious bias, by definition, it is a problem that the individual may find difficult to discount, whatever their sort of professed approach will be to decision making. That's why, if you think about Putnam in my submission, Lord Justice Bingham made it clear there comes a point where you have to discharge the jury if, for example, the poison has been allowed to spread for too long. The second point is, of course, that was all information obtained through the forewoman, and that is a problem because of the lack of any public record of what the jurors themselves said, and I'll potentially come back to that. The third point my learned friend made was that the Court of Appeal upheld the conviction. Unsurprisingly, we would say that the approach of the Court of Appeal, particularly paragraph 238, and I won't take you to it, everyone's familiar with it, obviously demonstrated a flawed approach. Some further points that my learned friend made to justify essentially the outcome in this case. The first was that the bribe was offered by someone who was seeking to favour the defendant. In submissions, unlike in writing, it appeared to be accepted that there's no evidence that any of the defendants was to blame for the bribe. That's important because it means none of them have taken actions which could in any sense be said to be effectively a waiver of their rights. But more importantly, Putnam is clear authority, and it's 7579, that there is a risk of prejudice against, and that's obvious. People do overcompensate. And then a friend said, you can tell that the jury is independent because it acquitted Mr. Williams. Already made the point, effectively, that we would submit that the jury simply couldn't lawfully deliver a verdict. But in any event, bias doesn't necessarily mean that someone will always deliver a verdict that is the verdict sought by the party they favour. Bias means, essentially, you're more likely to favour one party than the other. The fact that the evidence... put it this way. You can have a case where a biased individual acts against their biases because the evidence is so overwhelming. That doesn't mean they weren't biased. It doesn't mean that there isn't a higher threshold to overcome if the bias is against you. Bias simply means you favour one party over the other. I mean, that's, in our submission, fundamental. And that's why the acquittal of Mr. Williams, in circumstances where the evidence against Mr. Williams appears to have been particularly weak, dependent on Mr. Chow alone, doesn't necessarily mean that there wasn't that the jury didn't favour the prosecution in light of what had happened, unconsciously favour the prosecution. Now, my learned friend, in terms of jury independence and the relevance of Mr. Williams' acquittal, initially cited Gregory. Gregory, in fact, was the one where it was the case where the European Court found no violation of Article 6 in light of directions. Gregory, though, was followed by Sander, which my learned friend, I think, this morning accepted was the case where one person had been acquitted. The approach of the majority of the European Court was to find, and you see this at, I think it's 7956, paragraph 30, was to find a violation of Article 6 because a racist juror can't be expected to change their views in response to a direction. Now that is, we would submit, consistent with Putnam recognising that there comes a point, essentially, at which prejudicial views become so embedded that you can't change your mind. My learned friend pointed to the dissenting judgment in Sander, but that's a dissenting judgment. The majority approach in our submission is the correct one, as I say, reflecting Putnam, and that demonstrates that the real problem in relation to the second aspect of my learned friend's case, which is the impact on the other jurors, which is the judge simply didn't have the information to know whether or not this was a poison that could realistically be discounted on the basis of a direction. My learned friend also said you can discount unconscious bias because of the strength of the evidence. The jurors will essentially have said that they didn't need to consider the corruption because the case was so strong. The fundamental problem we would submit with that, ignoring some practical problems I'll come to in a moment, is that what that is doing is inviting the court to speculate about the jury's thinking. It doesn't know how the jury approached the decision making. by definition, the jurors may not know what factors, or every factor that influenced them. We are potentially talking here about unconscious bias, and that is obviously something that the jury won't necessarily be aware of. And it's particularly difficult for the court to understand effectively the impact of bias when it simply didn't sit through this long trial. My learned friend summarised the evidence, but just pick up a couple of points out of that, and a sort of fundamental point that's at the heart of this. He started by referring to Mr. Chow's evidence, but Mr. Chow's evidence was clearly rejected in part by the jury because Mr. Williams was acquitted. He then relied on the electronic exhibits, but there, as he accepts fairly, there were arguments about the integrity of those exhibits. That's a credibility issue. He finally says, the heart of the defence case was that various exhibits had been fabricated. That is a credibility issue. That's an issue that requires assessment of what the officers and others said in cross-examination. And we would submit it's impossible for this court, many years after the event, with transcripts but not much else essentially, to assess the extent to which the jury would inevitably have discounted, because of the strength of the evidence, prejudicial material. In any event, fundamentally, that explains why there is a right to trial by an independent jury, because it's for the jury to assess facts. What my learned friend's submissions do is potentially undermine that right, and that explains why all the authorities demonstrate essentially that the proviso doesn't apply. What my learned friend was seeking to do in my submission was seeking to apply the proviso, having accepted later in his submissions that the proviso can't apply to an unfair trial. Well, if it's a biased jury, you have an unfair trial. And that's entirely consistent with Serafin as well, because it clearly, if the jury was unlawful because it was biased or indeed didn't comply with the Jury Act, Serafin paragraph 49 in our submission makes it clear the verdict can't be upheld. In terms of directions, Bonnet-Taylor in our submission reflects the approach in Smith that directions must be apposite, clear and emphatic. The reference to Smith I gave in opening, it's 7671 paragraph 24. The direction in Bonnet-Taylor that was upheld at 629024 was a specific direction.
Sorry, 6290.
6290 paragraph 24.
Thank you.
And that's the context of what followed, which was the assumption that the jury would follow the direction. It's important to note, however, that paragraph 25, the statement that there is an assumption that the jury will follow a direction, was then followed by paragraph 26, which started with the word however, making it clear there was a degree of qualification, that emphasised the importance of the protocol, the need to investigate, because you can't, in one sense, rely on a direction until you're satisfied that the matter is capable of being cured. Here, the problem with the directions were, firstly, they were to a juror who'd already demonstrated they would not comply with the oath. Secondly, those directions were given in the context of what was, by our calculations, a 5-day summing up, where there had been repeated references to the need to comply with the oath. And that, in one sense, means this just looked like a repeat of those directions. And those directions had been given in the circumstances where it would have been clear to the jury that the judge was concerned that they might be influenced by the fame of at least one of the defendants. And so the focus of those directions was be cautious, you'll read a lot about this trial, essentially, but you'll be, and what the, and so there was essentially another direction, didn't expressly reference fame, but it was in the context of a situation where the judge was clearly expressing concerns about the impact of fame. In any event, as I say, we would say you can't give a direction that in circumstances where there is a risk of unconscious bias. It's very difficult to direct the jury in a way that will overcome that, if it's sufficiently embedded at least.
Why are we assuming it's unconscious bias? If every member of the jury has been approached and offered a bribe to acquit the defendant, someone would think it was a quite conscious bias.
Well,
the jury would think, but the law does not think, that would be a relevant matter going to their guilt or innocence. But of course their job is to decide it in accordance with the evidence. Isn't the real problem here that it would be a temptation hard to resist to decide or to be influenced in the decision of the case by something other than the evidence presented to the court?
Well, to be clear, I'm not saying it wasn't conscious bias. What I'm dealing with, what I'm dealing with is, in one sense, my learned friend's submission, which is to say, you can trust the jury to comply with a direction that they should, I mean, there is a problem with how detailed the direction was, but let's assume that the direction was sufficiently detailed. You can trust the jury to comply with a direction that they should disregard this factor. I mean, there's no reason in practice why it couldn't have said, because the jury were all meant to be aware of the bribe. I'm aware some of you have been approached about a bribe. You should. Now, the prosecution submission is you can trust the jury to comply with that. Whether that's realistic as a matter of human nature may be open to question. But assuming that's right, you still have the problem that even if a juror says to themselves, I understand that this looks pretty bad, that there was a bribe offered to us, but I understand what the judge has said. I need to put that out of my mind. It is very difficult, and this is why I focused on the unconscious bias aspect. It's very difficult as a matter of human nature to actually stop yourself unconsciously being influenced by that, because that's the way unconscious bias works. And that's why. It's because I'm in one sense focusing on a particular difficulty that in our submission simply can't be addressed by a direction. But I accept that in reality, conscious bias is a very real problem here. Yes, can I am in terms of the, just a couple of final features. Firstly, the procedure adopted. All we would invite the court to look at is, because my learned friend relies on it very heavily, Braithwaite 7358, the importance, in particular the citation at para 52 of an earlier case called Ball, the importance of matters being properly recorded in open court, which is the problem with the use of the forewoman, for example. That is important because it allows essentially